We have another exciting video for you. This video is going to be discussing the time frame on how long criminal case, more specifically a criminal case that is a felony grade and is before a superior court, how long it might take from the arrest up until a trial, what you may be looking at. And this is a question that we frequently get, and so we're happy to answer it. But I will say, before we jump into all of the good content, of course, it's going to vary by jurisdiction. Okay. And it also there's a number of variables, and I'll discuss those here shortly, that can lengthen the amount of time that you're looking at in the trial, as opposed to maybe shorten it. But before we get started, though, this video is for educational purposes only. This is not intended to be legal advice. And by watching this video, this does not create an attorney-client relationship between yourself and the law office of Shakhan and Wilkerson Law. Okay. All right. As always, again, thank you for joining us. My name is Attorney Shakhan. I am Genghis Shakhan, that is. I'm the managing attorney here at Shakhan and Wilkerson Law Firm. And we are a boutique law firm. And I say we, myself, and attorney Chelsea Wilkerson. We like being a boutique small law firm because we get to know our clients intimately, on a personal level. As we are working their cases, we find out about them, about their families, about what their legal goals are. And that's a little different than what some of our clients might experience had they elected to go with a much larger law firm, right? So that is something that excites us, kind of working cases in small batches, so that we can give our clients the personalized attention that each of them very much deserve. Okay. All right. So, what we're discussing today is we're talking about the timeline for criminal cases, felony cases that are winding their way through the Superior Court, what you might be looking at, right, in terms of time frame. And again, this is going to differ and vary by jurisdiction. Some judges' dockets move faster than others. Some district attorneys move faster than others. And then again, sometimes, a jurisdiction might be a little smaller than others, right? Some jurisdictions are very large. You talk about Fulton, or if you're talking about Bibb County or Chatham County, and then some jurisdictions are smaller. Okay, so it's counties in Middle Georgia, Jones County, Peach County, Crawford County, they're a little smaller. Okay. And so, based on the size, based on, again, the district attorney and his or her team, based on the judge's docket, and based on really the complexity of your case, it can take, it can take weeks, for your matter to be addressed. It can take months. It can take years. Okay, so I do have cases that have been resolved fairly quickly. Maybe something is being no prost and the state has decided not to pursue charges, or maybe a matter is just being dismissed. Maybe it just wasn't, there were missing elements to the crime, or maybe a matter is just going to be pending for a long time because of really the egregiousness of the act. Okay. And so I have clients, who are, they are accused of murder, and, so, or some other heinous crimes. And those cases, sometimes they can sit, okay, because there's a lot involved in preparation, all right, for those cases. Okay. All right. So we'll talk a little bit more about that. That's just really a quick little roadmap of what we plan to discuss over the course of this next 20 minutes or so, 20 to 30 minutes. All right, so I've gone through the disclaimer with you. And so this is a question we frequently get is just how long is my felony case going to take? All right, so let's talk about day one. Day one is usually the arrest. Okay, and that's where it all starts. At that arrest, you're being fingerprinted, and you're being booked. There's a mugshot. It might involve some jail. And you're possibly released. You can get a bond in some instances. The jail may already have a bond for you. Again, depending on the level of the crime, sometimes a jail will already have something posted for you, and you can go ahead and set bond and, walk out. Sometimes, again, if the crime is egregious enough, it might be non-bondable, right? Or you might have to go in front of a superior court judge as opposed to sit in front of that magistrate court judge to have your bond addressed. And so all of that could take usually several days, okay? When we're talking about post arrest, it could be the same day or it could take several days. Following that, usually you're looking at that first appearance, okay? And usually a first appearance is going to be somewhere between 24 to 72 hours. And at that first appearance, the judge is advising you of your charges. They're talking about reviewing your constitutional rights, and the judge might set a bond for you. Okay, if you have something that is bondable, a bond you've committed a bondable offense, and this again, if the offense is non-bondable, then you will more than likely have to sit and wait before you go before a superior court judge. If you're in front of a magistrate court judge, and again, all of this stuff is different again based on your jurisdiction. So if you have local counsel, they will probably advise you on how these things work in terms of time frame. However, if you have questions about first appearance, I believe we have a video here posted on our YouTube channel that specifically addresses first appearance. I would take a look at that. It goes into it in great detail. A lot happens at first appearance, and so it's probably a good idea for you to review that video. And as always, guys, if you find these videos are helpful, please make sure you like them. If you like legal information, maybe you're a legal nerd, make sure that you follow us, and make sure you hit the notification button so that when we're uploading videos that you're being notified. Also, if you have a family member that's perhaps going through a criminal matter, it might be a good idea to forward this video along to them, right? So any anxiety or apprehension they might feel about their case being addressed in superior court, their criminal case, this might help with some of that. Okay. All right. So we talked about that not arraignment. We're moving a little fast. First appearance. So first appearance, post first appearance. Now we're moving on to a preliminary hearing or a commitment hearing. Usually that is going to be somewhere within 10 to 14 days, if applicable. Okay. All right. So, and that's assuming that, a grand jury is not involved at these commitment hearings, and they can be really helpful for if you have counsel as a defense attorney. The state has to show some probable cause, right? And usually that's going to involve the presentation of some kind of evidence or witnesses, and it gives the defense attorney an opportunity to cross-examine and really get a peek see at what the state is trying to, in terms of the case they're trying to build, and what evidence they may plan to use in building a strong case. So it's awesome if you have a defense attorney that is going to take advantage of the commitment hearing, so that they can, again, get a kind of a jump start on building a strong defense for you. Okay. So post, well, if the grand jury it's involved and you've already been indicted, the grand jury is going to make a decision about whether or not there's probable cause to formally charge the defendant. Okay. And so there's certain outcomes. It could be a true bill or no bill. Usually you're talking about 1 to 6 months. Okay. And again, I'm gonna continue to say this. The caveat is that it differs by jurisdiction. Okay, but this is intended really to be, as I said, just a very general time frame, right? So just kind of keep that in mind because again, it is very different based on the jurisdiction that you are in. Okay, and so it's going to depend sometimes largely on what county you may have been accused of committing a crime in. All right. All right. So let's talk about arraignment. For an arraignment, essentially, you may have seen this on TV. All that's happening is there's going to be the judges doing a formal reading of your charges. That's where you enter your plea. Usually, that plea, I would say 99.9% of the time, it's going to be not guilty. And then this is really where the deadlines begin. And so there's a lot that's tethered to these arraignments that need to happen, in terms of for constitutional protections. But usually the arraignment follows several weeks after indictment. Okay. And so and it can, when I say weeks, it can be months. Okay. So that's something also to keep in mind. All right. The discovery phase. Okay. And so this is less formal, perhaps. I'm not going to say less formal, but it's different than what we would experience when it comes to domestic relations and civil practice. Whereas more formal, I don't like that word, but that's what I'm going to use, right? And so usually, and there's 6 months when you start talking about discovery in the civil practice, specifically domestic relations cases. And here, discovery can really begin at the outset of the case. And so it's often part time the longest part of the case. It involves the defense is receiving police reports, body cam, lab reports if they're involved, witness statements, medical records, jail calls, phone downloads, surveillance videos. All of this stuff is happening, and of course, it's up to the defense attorney to file that motion to invoke discovery. Okay, and so in order to make certain that they are receiving these documents and these reports and this media from the prosecution, as well as whatever law enforcement agencies that are involved in the investigation of the case. And so this is a fairly lengthy process, right? And so, I would say discovery, at least for me, begins really at the outset of the case and maybe doesn't conclude until we're at trial. Okay, and I think that that's probably the case for many attorneys, defense attorneys. Okay, so the defense is reviewing evidence. They are building defenses, and of course, addressing constitutional issues. And this can go on, for months. It can go on for years. Okay, and so just really again depends on the case, depends on the complexity of the case. That goes double for the investigation, right? Which again kind of starts at the outset of the case. The defense might be interviewing witnesses, visiting crime scenes, hiring investigators, hiring experts, reviewing social media, and obtaining records, etc. And so all of this is usually going to be happening simultaneously as the discovery phase, and it's just really going to continue probably up through trial. Would be my best guess. Okay. And so it's happening, as I mentioned, simultaneously. And then you have this motions practice, right? And this would probably have to be its own separate video, okay? Because there's so many motions that can be filed and oftentimes are filed in these felony cases, especially the serious felony cases, motions to suppress, motions in limine, things like motions to sever if there are a number of co-defendants, and like let's just say it's a big RICO case, okay? Bond motions, motions to compel if the opposing side being the district attorney, is not giving us the discovery that we're seeking. We might have to compel them to do it, right? By filing a motion, having a hearing, going before a judge, letting the judge know what's missing, what we expect to receive from the state and have not, and why it's important that we have it. All of this stuff is going to be happening again, I would say several weeks or months, really, into the case. Okay, and the judge usually in the judge's chambers, the aides are scheduling these hearings, and so some of this stuff can lengthen the case, because again, just depending on the complexity of the case. All right, and then you have plea negotiations. Okay, and this plea negotiations. So a lot of this stuff is happening simultaneously. So I don't want to walk away like, "Oh, okay, this stuff is happening in their own separate silos." That's just not the case. Okay, plea negotiations can happen immediately after an arrest. And they can happen during discovery, after motions, after trial, even during a trial, right? So, and sometimes it depends on the strength of a position, right? So, if the defendant has a pretty strong case, maybe they're in a position of strength when it comes to negotiating, because they may walk, and vice versa. If the state has a strong case, it might look different, right? And so those negotiations can change, the tenor of them can change along with the trajectory, right? Just based again on some of the evidence and the facts. And this stuff is happening, essentially throughout the life, maybe the life of the entire case. Okay. Calendar calls. Okay. So those calendar calls, you'll hear them. There might be status updates, trial scheduling, plea discussions, if there are discovery issues. And so recently had a calendar call in the last few days. This calendar call preparing for trial. Recently had an arraignment in the last few days. Some folks were arraigned. We filed waiver of arraignments. I didn't talk to you about waiver of arraignments, but again, sometimes you can waive, well, you can always waive a formal reading of the charges. Okay. And so that is always an option that your attorney will make you aware of. Okay. And then there's trial. Okay. So when both sides might announce ready, and that's going to be the district attorney or the assistant district attorney, as well as your defense attorney, announcing ready. We're getting ready for jury selection. There's going to be opening statements, evidence, and I'll do a video about what trial actually looks like, because that again is another animal in itself. Okay. But closing arguments, jury deliberations, all the way through verdict, that is again that can take one day, it could take 1 week. Okay. Or several weeks. All right, just again depending on the complexity of the case. A lot of witnesses, a lot of co-defendants, again, maybe there's a lot of evidence to parse through. Maybe this stuff is highly technical. Again, maybe the judge has a really busy docket. Maybe there's a lot going on in certain jurisdictions are very active, right? A lot going on. And so just really, really going to depend on that and complexity. Continue to talk about. And then sentencing. So sentencing can happen immediately after a case, or again, a judge can schedule for sentencing to happen a little later. I'm not going to really address appeals. That's on the back end of a case, and that can take years. Maybe we'll do a separate video on that. And but typical timelines, can be months for simple felonies, and again, it can be years for things like murder. It just really depends on the case. All right. Now let's talk about really quickly some things that can speed up your case. Things like entering a plea agreement, obviously, early on is might be kill the case. Um, Discovery being in, not having to file motions to compel it, having fewer witnesses, right? The defendant being out on bond, which is usually important because the defendant can help in bringing in stronger witnesses, helping build a much stronger case. The prosecutor and defense attorney both being prepared, announcing ready, and then court availability, right? Or if there is no contested motions, okay? Or if someone asks for a speedy trial, right, to be heard in the next couple terms, okay? Those things can move a case along rather quickly, and make it so that the case is not pending for years, right? Which happens. Okay. And what can slow down a case? Again, if the case is really egregious felonies, things like murder, capital cases, multiple defendants, DNA testing needs to come in, crime lab delays, which happens, digital evidence, numerous witnesses, out of state witnesses that have to be, brought into the state of Georgia, expert witnesses, mental health witnesses, if the court is just congested, again, you're in an active jurisdiction, co-defendant issues, right? Uh, Judge availability, discovery disputes, all this stuff is going to slow your case down, and it can slow it down to a snail's pace. Just depending on you might have a perfect storm of all these issues, okay? And so that can basically bring your case to a grinding halt, okay? Now, should you want a fast case? I'm going to say not always, and most of the time, no, because you want your attorney to have an opportunity to do a full and complete investigation. That's going to come with time. Investigating the facts, investigating these incidents, they normally take time. Okay. And you might get a better plea if you take a little time. For example, if rather than trying to plea in the first year or two, if you wait, until the case is almost ripe for trial, maybe you get a better plea situation. Again, stronger defense preparation, witness interviews, all of that stuff is going to come with time. So sometimes time is your friend. Many times time is your friend, but it's hard to really say that to a client or a defendant, right? So sometimes it's important to be patient. All right. Now here's some common misconceptions. One is the biggest is that, oh, my case is going to be over in a month. I mean, that's just not how these criminal defense cases work. They just usually they can go on for a good amount of time, a good clip of time. Or if you people will think I'm not hearing anything from my attorney, so nothing must be happening. And the reality is, much of the legal work happens behind the scenes. So discovery review, investigations, legal research, negotiations, motion drafting. Most clients never see that stuff, right? And so you might see the end product. You might see a hearing because of a motion that was filed some time ago, and in that motion there might be some legal arguments that were advanced, and there might be a lot of case law and research, legal research that went into that. And so many people just don't see that part of it, unfortunately. That's why attorneys get the big bucks, right? So as final advice, I would say it's important to stay in contact with your attorney. And then, of course, follow all bond conditions. If you are out on bond, don't discuss your case with anyone but your attorney. I would say stay off social media. We always try to give that advice, and be patient and really just really trust the process. Okay. All right, guys. If you are in need of a criminal defense attorney, right, or if you're in need of a domestic relations attorney, we will be happy to help you out here at Shakhan and Wilkerson Law Firm. We are pleased to offer things like financing and some other options to essentially underwrite the cost of your case. In addition to that, we take our clients and their cases very, very seriously. And if you need consultation because you are looking to retain an attorney, you have two numbers you can call: 404-999-9529 or 478-845-1213. We would be more than happy to take on your case and help you out. Okay. All right, guys. Thank you for joining us. Again, if this has been helpful, make sure you like, follow, and share, and turn on that notification bell. All right. We'll see you next time.